All right, folks, there's something that the U.S. Supreme Court failed to do, which should concern every single one of us, and basically this has flown under the radar as well. And joining us now to talk about it is William Olson, a constitutional and election lawyer, and he filed, and his organization, the William J. Olson Attorneys at Law, filed an amicus brief in the Hedges case, the National Defense Authorization Act involved here. And William, welcome, sir.
Nice to talk to you, Steve.
Well, this is very important, and you know, I just I don't understand the media in many instances when something like this just goes unreported and nobody talks about it, because we need a very robust debate on this, which is why I'm sure you filed the brief. And basically, the court's decision means that the federal government, in the eyes of many, and I'm sure in your eyes, has an open door to detain as a threat to national security those who they view as troublemakers. True?
Absolutely. This is a rather remarkable shredding of the Bill of Rights, because we have in one statute that Congress passed, the National Defense Authorization Act of 2012, and it's been repeated since then, this rather amazing authority to grant to the military the ability to pick up people. The term they use is covered persons, and then they have used some very, very loose words about people who support in some way Al-Qaeda or the Taliban or associated forces. And it'd be nice if they had some precision there, because the people who challenged it were journalists. Chris Hedges, who Pulitzer Prize winner and New York Times reporter before, and he was in court and saying, could you pick me up if I wrote a story after being embedded with Taliban or other groups, and I'm just writing a story? And the government, I believe it was 3 different times, Judge Kathleen Forrest in district court asked them, could he be picked up for that? And they said, we can't say. We'll get back to you.
That is chilling. That is chilling.
And this is an Obama-appointed federal district judge who enjoined the President of the United States and said this cannot stand. So it wasn't exactly a partisan issue. And
right.
Here, most of our clients, Congressman Steve Stockman and Virginia Delegate Bob Marshall, who was the guy who wrote the first law where Virginia said, we will not cooperate on picking up any citizens of Virginia and putting them into your hands, and Gun Owners Foundation and U.S. Justice Foundation, all these groups, including liberal groups, Center for Media and Democracy, they all got together. They understood the threat. And yet here we have the Supreme Court having an opportunity to straighten this out, because after Judge Kathleen Forrest enjoined the President, the Second Circuit suspended that order.
Right.
And here we are in a situation where the Supreme Court says we don't think we really have to decide it. It's not all that important. We have other cases that are more important.
Well, let me interrupt you and ask you, for the layman like me, and I ask this often when the court kicks out a case or declines to hear a case, but and I don't know if it's different from each time, but who made this decision? Was this one judge? Was it? I know sometimes it's their turn. Was this one judge who said no? Could the court still be petitioned to the full court, or was this the full court who said no?
No, it's the full court that says no on the denial of a petition for certiorari. This case had a lot of attention, quite a number of amicus briefs. I mean, we filed 3. We're the only groups that filed 3 in
Wow.
District Court of Appeals, and they knew what was going on. They decided they did not want to touch this. The establishment powers that be in both parties apparently want to entrust the President of the United States with this power to detain indefinitely without charges, without trial, without an arrest warrant, without a grand jury, just be able to hold someone who they think might be a threat of some sort. And they didn't tackle the issue. They ducked.
Now this would come from executive order. Let me ask you a question. I guess all bets are off if there's some kind of martial law declared, and that's a different situation. But what's to stop any president, I want to make that clear, any president, from having an enemies list or not liking this reporter? And we're talking about reporters here. You mentioned, of course, Chris Hedges, but it could be other people, not in the media. But I guess since I'm in the media, I'm thinking out loud. What's to stop a president from not liking all of a sudden conservative talk show hosts where they're saying things that he feels is really he could claim is putting the country's security in jeopardy, or a conservative president that says the same thing about the host on MSNBC. Under this, are you telling me that theoretically, if the president, whoever he or she may be at the time, says these people are really, because of what we're going through here, whatever that might be, these people are national security threats, could they be rounded up under this?
This appears to be a power that's vested by Congress, and this is not just an executive order where the president had no statutory basis for doing what he did. This is actually a statute that gives the president the power to round up these people. And who decides what substantial support is? The president, the military. And if they decide it, how are you going to challenge it when the black SUVs roll away from your house and no one even knows where you've been taken?
Has this been used, and would we know if this has been used?
Well, we really don't know to the degree to it's been used. The Justice Department came in and said, we've always had this authority. This was given to us by Congress right after 9/11 in the enactment of the authorization for the use of military force. Of course, that statute was meant to give the president power to go after people who had participated in 9/11 or were about to launch other strikes. It was a completely different context. Didn't say anything as the NDAA provision said about just general hostilities, a general war on terrorism. They've claimed this authority since 2001. President Obama did it, Bush did it, and the real question becomes, now we had a chance to have the court decide whether the president has this authority or not, and not in the context of a case that might or might not ever be heard of, might never get to court, but as a matter of principle, does the president have this power? And the court said the Second Circuit, and by the way, Steve, the Second Circuit did not rule on the merits. They said they didn't have standing to consider this.
That's what it was. So they said that who didn't have standing to consider it? Them, the court?
Hedges? Well, they said
that Hedges, the plaintiffs.
Exactly.
Hedges
did not have standing to bring the case.
Well, then who the heck would? I hate that part of the law because I guess there's a value to it. But when we talk about with Congress people here, that the president's violating the Constitution or violating the law because he changes it unilaterally, but they don't have standing to bring a case, and we saw that with the Supreme Court in other cases as well. With Congress can't go before the court; they don't have standing. Well, who in this case would the court say has standing to bring this? Who would have to? Someone who is already harmed? Is that the only thing?
Well, that's the implication you have here. And you're right. You're right. The Constitution says courts only resolve cases or controversies. Standing is an important doctrine, but when it's used as an avoidance technique to get around deciding cases that the court was there to decide, that's when it becomes a real problem.
So if you have to show damage or that you've been damaged, then it's either got to be a family member of someone who was taken under this, or someone who was taken under this, and I guess then let go. I don't even know. I can't even conceive of who they would believe would have standing. Now, finally, and we only have a minute and a half. Can the Congress remedy this?
Anytime they wanted to, they could. The problem is the Congress, and neither party of Congress has the appetite for it. I mean, you have the Senate is deferring to people like Lindsey Graham when he says the whole world is a battlefield and we need to give the president the authority to act against American citizens. As a matter of fact, he said if we can use drones to kill American citizens overseas, don't you think we can use the president's statutory authority under this law to be able to just pick them up and hold them? That was one of his arguments.
I'm all for national security, but in my view, from my read on this, it goes way, way too far, and I would have felt much better if the Supreme Court would have heard arguments on this. William, I got a feeling this isn't the end of it. William Olson, thank you very, very much, sir.
Thank you, Steve.
Take care. Well, what can I say? Sometimes you ask yourself, what country are we living in? And yes, in 2001, the intent, I could understand that intent, and I would have favored it back then. But it seems like the intent has been broadened and weakened and watered down. All right, we're coming back, folks. The panel, don't go away.